Okay, I think we are live. Welcome to the channel. I have Stoic from Coast here, and I think we're going to have a productive conversation. I'm going to bring him right in. We're going to talk about some basic things, and then I hope we can have some time to also answer your questions. And let's get right into it here. So here's Stoic. Hey, Stoic, how are you?
Hey, Max, I'm good to be here. Thank you, sir. I appreciate
Thank
everyone who's tuning in as well.
Thank you for doing this. I think that you do have some good background, and I'm looking forward to talking with you. And I think this is going to be hopefully really productive. Um, I want to ask, first of all, what is your background and what is your experience, and why are you worth having on here and listening to when it comes to some of the regulation and security questions around the Richard Hart ecosystem?
Yeah, thanks. So, um, first disclaimer here that I have to make is that we're
Yep.
here talking about regulations. We're here talking about the SEC, and I personally am not a lawyer. So, nothing I say can be considered legal advice or legal opinion. But my role at Coast is that I'm a product lead. And so a huge part of what I do is collaborate with our legal team to review regulations and design software that meets those regulatory standards. And I kind of think it's a little bit surprising that this isn't more of the standard in our community. One of the key lessons that I learned from Richard is that if you take the time to understand regulatory frameworks, agency mandates, legal precedent, etc., you could design software that either falls specifically within or specifically without or outside the scope of different regulators. And so HEX is a beautiful example of this, right? The reason you had to mint your own HEX at the end of each AA was specifically so there was no entrepreneurial or managerial effort or work being performed by others, right? You mint your own rewards. And somehow in the last couple of years, everyone's sort of lost sight of that being the key thing that Richard was trying to get across when he was designing that product, right? And there's a few
Right.
tools out there at the moment that are being released by the community that pretty clearly violate this principle. And that's tempting to do, right? It's easier to code, it's faster to get a
Yes.
product to market, it's often a simpler user interface and things like that. But we have to bring this back and we have to raise our standards and we have to remember that we're operating, even though it's crypto, we're operating within regulatory frameworks. This is a little bit different for us, right? We're trying to create a fiat on-ramp to Pulse Chain. We're trying to make a frictionless way for people to get economic energy from their bank account onto the chain. Now, that could be with our own stable coin, although we're also exploring ways for people to potentially buy other things. We're trying to avoid custody. We're trying to have minimal KYC, right? But all of these things require us having regular discussion with regulators and our attorneys about how these things are going to work. And so my background here, like I said, I'm a product lead. So I'm in between the developers group, and I'm in between the business operations and our legal team, trying to make products that satisfy everybody. So, with that said, like, we get legal advice about absolutely everything, right? There are things I can't say on stream, unfortunately, that I can't discuss, but I've spoken with a few people about privately. HODL law versus the SEC, for example. Look, every time there is a major judgment, I have our securities attorney write an analysis for me. He did this with HEX subpoenas, he did this with LBRY, he did this with HODL law, and I speak to our securities attorney twice a week. So this past Sunday, he left a Thanksgiving football party to call me and talk about HODL law, right? Like, that's the level of interaction that we're having with these people. So we spend as much money on legal advice and processes as we do on developer resources. We're talking to FINRA, FINCEN, and the SEC about the Coast stablecoin, because we actually want to be completely transparent about even a stablecoin talking to the SEC, right? We're going above and beyond in terms of communicating with regulators. And every single jurisdiction that we plan to operate the Coast stablecoin or a derivative thereof, we have to have like reference letters written by our attorneys given to our banking partner who we recently signed for every individual market. That means the UK, the EU, Australia, every market we have, We have to have an attorney look at all of the code, look at the regulations, apply it to our product, and then give us feedback on how we need to change things, tweak things, or licensure that we need to apply for. So I think that's a huge amount of information. Yeah, you have any questions about that?
Yeah, that's great. So one clarifying question. So we've mentioned the SEC, FINCEN, and FINRA.
Mm-hmm.
Can you explain what those three things are?
Yeah, sure. I think everybody should be familiar with the SEC, right? The SEC regulates more than just securities. Probably most people don't actually realize that, but the SEC also regulates the conduct of investment advisors, for example. Right, so it deals with how securities are to be sold. Deals with the licensure for individuals to do that. It mandates, kind of like a real estate agent would mandate, that you have to have a broker and a sales agent, and the sales agent is sort of interning with the broker. There's a similar situation with sponsoring brokers in securities law when you're dealing with broker-dealer licenses and stuff like that. So it's more than it seems. And a lot of people just think, it's dealing with high-level security stuff. It is, but there's a ton of stuff within the department that people don't think about, and investment advisors are one of those things.
It clarifies like how someone interacts with securities as well, and if you meet qualifications for that interaction. Is that correct?
Yeah, exactly.
Is that a way of saying it? Okay, awesome.
So then we can move on and talk about, say, FinCEN, right? Yeah. FinCEN is the Financial Crimes Enforcement Network. It's a bureau of the Treasury, really, and it analyzes information about financial transactions to combat domestic money laundering, terrorist financing, financial crimes, etc. FinCEN is an organization you have to register with if you're a money services business. FinCEN is also the organization to whom you would have to send reports if you found that in the course of doing business, one of your customers was participating in potentially money laundering activities, right? So there are things that we have to report because we're trying to interface with TradFi via a fiat on-ramp. We have to have procedures in place to not only prevent those transactions from going through, but also automatically report them to FinCEN. So that's something that we have to deal with quite a lot. It's not what a lot of cryptocurrency firms deal with, because typically people are just working within smart contracts or within blockchain tools. Generally, most of them don't have that level of requirement in terms of dealing with them as a regulator.
Okay.
Yeah.
Got it. And then what about FINRA?
FINRA deals with like funding portals, capital allocation brokers. FINRA is sort of looking at the people who are raising money and how they're doing it. And there's an office of an ombudsman that deals with this. There's a dispute resolution forum for large scale securities and things like this. It's really like the organization that deals with like education and training for brokers, compliance tools, etc.
Got it. So earlier you mentioned, and I don't necessarily want to name any names, but is there examples of what our community should be avoiding? Is there like something that a way that sometimes people go about something that may not be the best way to do it when they're creating their project, for example?
Yeah, certainly. It depends who you're really speaking to in this case, because there's best practices for issuers and developers, people who are running a project or releasing a product. There's also best practices for people who are speaking about projects, right? Yes. So in terms of the former, there are pretty concrete ways to like release a cryptocurrency and try as best you can to do it in a legal way. Some of those things would be, not having a pre-allocation to yourself as others, not selling the currency directly, doing it through a quote unquote regulated exchange, completing the project prior to launch as HEX did, and then never promising anything to do with anything with the currency, right? All of the things that sort of tie back to the Howey Test of what is a security, and those are the ways you would try to launch something if you're a founder in a legal fashion. Then you have sort of the other issue of in the community of, there's a lot of people who are doing live streams, who are tweeting, who are being active online, who are espousing the virtues of the HEX currency, the HEX contract, Richard generally, sacrificing for Pulse Chain, etc. And look, I see a lot of this going on online, and it makes me anxious because I can very clearly see that people who are doing these things are moving over into investment advice,
right? And
they need to stop. Like, please stop giving investment advice, especially on YouTube and Twitter. Like, people need to understand a licensed investment advisor, even, right? Most of these people are not licensed investment advisors, but even a licensed investment advisor does not give out general information to the public about investments. They are required to have intimate knowledge of the individual or entity that they're advising, and no two investors are the same. So it's absolutely irresponsible for an investment advisor or someone playing an investment advisor online to give advice to two or more people simultaneously. Further, the profiles of investors are subject to change over time, and especially in cryptocurrency can change rapidly. So an investment advisor needs to know, the employment status, the gross and net income, the fixed cost, the risk profile, and tolerance of all of the people they advise. And they do that in a one-to-one fashion. So unless you're a licensed investment advisor, and unless you know all of these things that I just outlined about every YouTube viewer who is watching your content, which is absolutely impossible, just stop giving investment advice, please.
Yeah. Do you feel that, like you kind of did, but I'm curious, is there a definition of investment advice? Like, I feel if I was to try to answer that question, it would be something like telling people what to do with their investment would be investment advice, which I think might be a little bit different from showing people what you are doing. For example, like, I'm interested in this project myself for this reason, might be a little bit different than you need to invest right now. This is the bottom, or you're going to regret it later or something. Like, does that make sense? Is there...
It does, yeah. And maybe the best example of where this line gets blurred and where it can be made more clear is in terms of GameStop, right? I don't know if you're following that, but the term "I like the stock" came and became pretty popular online, right? Yeah. I like the stock is not investment advice, right?
Yes.
But hey, buy it, it's going to the moon. Yes. That's investment advice. And we need to stop doing that. And that's where the line can get blurred in people saying, well, here's how you can use this tool. Here's how you can interact with this smart contract via this particular front end. And that very, very quickly can become, as soon as there's a YouTube comment and a response, can very easily become, just buy HEX. Why would you do that? Why wouldn't you just buy HEX?
Yes.
And that particular phrase or phrases like it could very easily be construed as investment advice.
Right. That's good. So do you want to talk about anything specific? Let's just start with HEX. Do you have comments on, maybe we could just talk about HEX and the Howey Test? Do you have opinions on what the Howey Test, as you see it, is, and how HEX... you don't have to answer. I don't want to make you answer any more specific than you should, but is there, how do you feel about HEX and the current interpretations of the Howey Test, for example?
Yeah, sure. So it sort of comes back to what I was talking about with those sort of core components of how you would launch a crypto legally if you're a founder, right? Don't pre-allocate. Don't sell the currency directly. Don't release the project as a completed product, and then never promise anything. Those are the four sort of central tenets of how you would do this. And HEX, for the most part, I think probably entirely meets all of those standards. Again, I'm not a securities attorney, but there are a lot of things that HEX has in its favor, right? Like, HEX was released as a finished product. You had to interact with the smart contract via the AA to obtain HEX originally. HEX has a legal opinion that was published before the currency launched, before the product launched. An interesting thing to know about legal opinions is that they're typically actually more expensive than going and obtaining a no action letter from the SEC. Getting a legal opinion on something like HEX with all of those lines of code and the complexity involved in it, I know that the guys from Discourse Syndicate, Kinetics and RG3, I think we're talking about it the other day, the complexity involved in that contract, you have to be able to explain that to your attorney such that they can understand it, so they can write the legal opinion. And that's a very, very difficult thing to do. I mean, even with simple contracts, it's hard, and HEX is not a simple contract.
Right.
The only issue with this, though, is that a legal opinion is less powerful than a no action letter from the SEC, because it requires you to then go and defend yourself in court if any sort of case is brought against you. It is not a predetermination by the SEC that they are not going to bring a case against you. So more difficult, more expensive, potentially less powerful in terms of dealing with a regulator as well.
Can you describe what a no action letter is?
Yeah, sure. These are things that exist in a whole range of different departments across government, and they exist in the United States. They exist elsewhere as well. In the case of FINRA, FINRA doesn't issue a no action letter. They issue a regulatory statement. In the case of the SEC and I think the EPA as well, they're within their rights to issue what's called a categorical exclusion. Primarily in the case of the SEC, which is who we're dealing with in this case when we're talking about HEX, that you would present to them your business model. You would explain to them how it relates to the code as it's written. And I mean the regulatory framework. So there's a thing in all of these departments, again, called the Code of Federal Regulation, or the CFR for short. And you would address in your letter to the SEC how your project meets all of the requirements of the Code of Federal Regulation. And then you would request that they verify that. And you might wait 4 months, you might wait 6 months, but you will get a response from them. And typically you actually have to submit this letter and then call them to verify that they've actually received it. For some reason, dealing with this, you actually have to make phone calls, strangely enough. Once you got clarification that they've received it, you'll get told that they're going to respond to you, and then in due course they will. And typically they're actually fairly collaborative about it as well. As written, your project does actually meet the definition of a security. However, the several options that you've provided for this particular feature might mean that it does not. And you can actually get that. It's almost like you're dealing with your attorney, and it's the same sort of process. But you do get feedback from these departments.
That's so extremely valuable, I feel. I love that. I didn't actually know there was a process for that. And of course, I think one thing that I feel would be worth emphasizing with that is it's probably going to be as valuable as you presented your idea accurately, because they're going to go off of your letter, right? And if your project is any different from that, it's not going to count.
That's exactly right. You're issued a no action letter based on the project or the product that you say you are going to release. And if you defer from that in any way, or if you go off on a tangent, if you add an additional feature, it doesn't mean you can't do your project. It just means you have to amend your request to the SEC and go back to them and ask them to clarify, based on the new information, a new no action letter.
Is this something that could be done after the fact as well, once the project is live?
Yes, it could be. The issue a little bit there is that typically you would want to have it, and you would get legal advice to go and get it prior to releasing a product.
Yes.
Unless, for example, in the case of HEX, you had a legal opinion that you felt comfortable with proceeding. Sometimes you might want to do a legal opinion because you don't feel like the time frame for the SEC, it's not a set, we will get back to you in 90 days kind of deal. So if you don't want to work within their time frames, you might feel it's more appropriate to go with your legal opinion and let the chips fall where they may later on.
Okay, so I'm curious now, Pulse and PulseX, do we even have a legal opinion that you're aware of for either of those projects?
So a legal opinion would have to be paid for in the case of these. There are some blog posts that were written in 2018 after the ICO craze of 2017 that suggested that this sacrifice mechanism would be a reasonable way to try and raise money without doing an ICO, without registering as an initial coin offering with the SEC. It's something interesting to know that people don't often realize is that you can actually do a legal ICO. You can go to the SEC and apply to do this, but most people don't because it takes too much effort.
A registered ICO, I believe, right?
Correct. Yes, exactly. Yeah. So you can do that. There hasn't been a case brought by the SEC yet against anyone who has done a sacrifice or has used that as a fundraising mechanism. I would expect that one will happen at some point in the next few years because these have been going on for a couple of years now. But where something to keep in mind also in this space is that the statute of limitations for securities violations has been increased to 10 years. So it used to only be 5.
Oh my goodness. I've heard about this.
Yes, this changed last year and a lot of people don't know about it. But now, it used to be that people were thinking, all right, we'll wait this out for 5 years and we'll be okay. I think that's what LBRY, which we're hoping as well. And now it's going to be 10 years. So, we won't get clarity on a non-action by the SEC for a decade.
Is there some of the non-Richard Hart groups I'm a part of are actually very concerned about that particular 10-year retroactive clause, and the way that they were explaining it to me was they were actually very concerned because they felt that the SEC could change their rules within 10 years and they might find themselves in trouble, basically, even if they felt that they were reasonably within the current understanding. They were afraid that the SEC could change something in the future and then be guilty. I'm curious if you have thoughts on that. Is there any truth to that?
Well, the SEC would likely have to prove in court that they had a right to do that. They would probably have to, in pre-hearing motions, they would have to specify that the people who produced the project knew that this legislation or these CFRs were subject to change. So you might not even get to trial necessarily in that particular case, but I can't speak to it for certain.
Yeah. Okay. Okay, so from what you've seen, PulseX, HEX, there's not, I don't want to necessarily be too specific, but right now we don't have, from the broader understanding of regulatory concerns, we don't have reason to be extremely alarmed. Is that a fair question? Or is that a fair statement?
It probably depends a little bit on who you mean by we. A HEX holder who has interacted with the contract and who has never said anything publicly about HEX and hasn't participated in a Telegram group and etc. They very likely have very little to fear from being a HEX holder or a HEX staker or anything else. The question is really going to be, and this was something that came to light in these SEC subpoenas, where a lot of people in the HEX ecosystem were receiving these, they're not court-ordered subpoenas, they're just issued by the SEC in sort of like a fact-finding mission. And I think the effort from the SEC there is really just to find out more information about how HEX was launched and about how HEX was promoted, and to see if there were people who were participating as paid employees of the issuer, etc. So as of this point, there's no regulatory action planned as far as I know. They're really just in a fact-finding stage. And the issue for Pulse Chain and PulseX will largely be dependent on what is found in the course of doing that investigation into HEX. Because if there is a big data dump by someone who receives one of these subpoenas, it could certainly be the case that the SEC would find information about the Pulse and PulseX launches and sacrifices, etc. And they might decide that, okay, well, it's now part of our due diligence to go and look into these projects as well, and the launch mechanisms and the fundraising mechanisms that spurned them. I think they probably will have a mandate to do that if they've received complaints from American-based investors or sacrificers who put money into those projects. So they would be required to do some sort of investigation into it. Again, it doesn't mean they're going to start bringing legal cases against anyone. It just means that they're trying to find info.
So if, like, historically speaking or whatever, if they do find something that they don't like, what tends to happen? I've seen fines as a common thing from my, very distant viewing of this. Is that the tendency is they impose a fine if they find something wrong?
Yeah, it kind of depends a little bit on the intentions of the actors that were in there. If there was an intention to defraud people, let's say hypothetically that Richard never had a plan to create Pulse Chain in any way, shape, or form, then if that was discovered in the course of some investigation, that could be referred to the DOJ, right? It's the intention of the people involved.
Can you clarify the difference between the DOJ and the SEC? Because I think sometimes people almost put them together in one.
Yeah, sure. So they're both federal agencies, but the SEC has a mandate to protect US investors, right? That's what they're out there trying to do. There's been numerous pieces of legislation that have brought the SEC, more power over the years. 2113, I think, on virtual currencies, R001 on issuing negotiable certificates on blockchain, which was released in 2015. There's been numerous different pieces of legislation that have given the SEC more power. But the SEC primarily is out there trying to ensure that American investors are not defrauded and that they're not put in a situation where they're investing in products that they do not understand or aren't sophisticated enough to understand. So they set minimum standards for what is considered an accredited investor. And you're supposed to, as long as you're making more than 200K or you have liquid net assets of more than $1 million, that's supposed to accredit you in a sense as a person who has financial literacy to an extent that you can invest in securities or non-registered securities. If you were an issuer and you were trying to release a project like this, if you were trying to do like an unregistered security, you could do that by filing a Form Reg D. And then you would get a Reg D exemption from securities law, but it involves going to the SEC and saying, hey, here's the securities offering that I'm doing. I'm requesting that you give me the right to do this because I'm issuing or I'm filing a Form Reg D. And so I should be exempt from securities law. There are requirements that are placed on you, right? You can only take accredited investors. You can only raise for certain periods of time. You can't do an open-ended fund. So there's a whole bunch of limits that are placed on you. I think this is what the guys from Discus Syndicate did through Mountain Crypto Advisors and through the HEX Investment Trust. So they're familiar with all of this stuff too, going through that process. So they have had to file that paperwork with the SEC, for example.
Right.
And then, DOJ, federal institution, primarily, or in this particular case, they would be charged with, looking into cases of fraud, looking into major cases of mismanagement, looking into financial crimes generally. And in a lot of circumstances, the way they would do this is by going after a RICO statute case, trying to see if there was collusion to defraud people or manipulation of a market in some way, shape, or fashion.
And so would the Department of Justice be more of a, would they be more of like, is there jail time associated with the Department of Justice, for example, that the SEC may not impose?
There certainly can be. Yeah, absolutely. Yeah.
Because the SEC...
The FBI is the principal investigative arm of the Department of Justice. So anytime you see FBI cases or federal cases through the FBI, remember that they're just a sub-branch of the DOJ.
Got it. That's good. Excellent. So let's see. I see Tin Top has a question here. It reminds me of what you were just talking about. So could this fact-finding exercise be related to the HEX Investment Trust Aren't they a registered security? Did their application provide any clarification on HEX not being a security? I don't know if you want to talk any more to that question, Stoic.
Yeah, look, I can a little bit. I'm going to refrain from making any sort of detailed references to the HIT. I'm familiar with it. I have, gone through a similar process to create a hedge fund, which involves doing that Reg D exemption, like I said. So aren't they a registered security? Yes, they're a registered security in the sense that they can take investor capital. They can only take it from accredited investors. And those accredited investors need to sign what's called a private placement memorandum, which is commonly referred to as just a PPM. A PPM is a fairly exhaustive document. I think ours for my hedge fund is about 150 pages of information. I would expect that theirs is something similar. But yes, Tinsob, in the course of going to the SEC and filing that for that Reg D exemption, I believe the HIT provided information about HEX, including the previous legal opinion that was obtained on behalf of HEX. There are some intricacies to a trust specifically that I'm not familiar with, so you might have to take that question to the guys at Discourse Syndicate to clarify that exactly. But yes, they did provide some information on HEX not being a security.
Cool. So if there were fines, I get this question every once in a while, who would be fined?
It's a very good question. It depends on the infringement that has been brought, right? So this is why we were talking a little bit earlier about the difference between an issuer and a promoter, right?
Yeah.
If someone is out there promoting HEX and they're doing it in a fashion that is considered investment advice, well, they could potentially have a suit brought against them, which would require them to pay personal fines.
Yep.
I think there is some behavior in the community that potentially warrants that, frankly.
Yeah.
I wish it upon anyone, but that's a very real potential outcome. In the case of the issuer, though, it's a little bit different, right? Like you could find fines being issued. You could, I think probably in the case of this, that the best case for issuing a fine, for example, would be because the SEC has deemed the adoption amplifier in HEX to be some sort of fundraising violation in some way.
Yep.
I think it's very unlikely that the SEC could look at the HEX contract the way it currently functions and deem it a security and bring a case against anybody because there is no entity to bring it against, right? But there is the potential that they could, say, go back and look over with a fine-tooth comb the adoption amplifier, the behavior involved in it, and say, well, this maybe was an illegal fundraising mechanism, in which case they could bring a charge or a case against the creators. I don't think they would be successful, frankly, but there's certainly the potential that they could try. The result of something like that could be a settlement in which case the creators could be forced to repay investor money, for example. So, I don't even know how you would do this, but you might have to be required to refund all of the ETH from the adoption amplifier. I don't know if you would have to do that at ETH value or at USD value at the time or USD value now. It's a very complicated thing. I don't think it's probably worth exploring all that much more. In fact, I've probably answered too much about this. I don't think this is a likely event to ever occur. So probably not worth pontificating any more about it.
Got it. Let's see here. Here is a question from UFO to go. He says, the problem is a lack of contract to investigate by the SEC. Without a contract, the authority has no facts to investigate and determine a penalty on. True?
I think they're talking about, in this case, a contract between an investor and the issuer. And in that case, you're probably correct. It would be difficult to investigate and determine a penalty. I think that's correct. But I would seek legal advice on that before I answer for sure.
So do you have is there any other thoughts for our general community? I feel like I've heard you say for people like me, people that are posting on social media, be very careful of giving investment advice. Be careful and watch yourself, because even if HEX and the project you're talking about do not have issues, it doesn't necessarily give you freedom to talk about them however you want. That sounds like something. Did I say that right? That sounds like a takeaway from this?
Yeah, absolutely. I would encourage everybody who's speaking publicly to look into what constitutes investment advice. Further, I would really encourage everybody, instead of poo-pooing or ignoring, subpoenas and communications with regulators, etc.
Yes.
I was stunned by the number of people who came out and said these subpoenas are fake, or even worse, started saying things like "come get us, we know we're not a security," etc. It was startling, frankly, and I think we need to stop doing that. I think, for example, that the LBRY case showed us why you shouldn't do that. You're not doing yourselves any favors by taunting regulators in that fashion.
Which is what they were doing, right?
That's exactly
They
right.
were explicitly taunting regulators, which anyway, yes. Go ahead.
Look, I wouldn't be doing that. I don't think it's smart to do that. I don't know that the very cheap, small number of internet points that you win within a community who probably already likes you is worth doing it over. Like what is the gain that you've actually created for yourself there? I don't think it's worthwhile, but apparently some other people have.
Yep.
I just want to maybe talk about that a little bit more.
Yeah, go ahead.
So like these subpoenas that come out, we were talking about like what the effect on Pulse Chain could be, right? What the effect on Pulse X could be as a result of these subpoenas. I think the very likely result of them is a chilling effect. And we've already seen this in the case of the people who received these subpoenas, saying, we're shutting down our YouTube channel, we're going offline. Some Twitter accounts disappeared altogether. Other people making final statements about how they weren't going to say anything else. And look, these are probably well-intentioned, and they've probably got good advice from lawyers to do things like that. But I think this is where you can see a chilling effect on investment in projects, a chilling event in talking about projects, and a chilling event effect on potentially releasing projects. I am not in Richard's ear. I am not giving him legal advice. Right. But I can imagine that if I was in his case, my lawyer would be looking at me being like, you're going to give back all of that sacrificed capital, and you're not going to release that project. Otherwise, you're going to go to jail. Now, that's not necessarily the advice that he's getting, and it might not even be correct if it was what he was getting. But you can certainly see how regulators looking into these things like that could chill productivity. And that's not just for Pulse and PulseX, right? Like there's probably a chilling effect across the industry from the fallout from LBRY. And you could see the same happening with the HEX subpoenas on general conversation about projects. So, it behooves all of us to educate ourselves, be familiar with regulation, don't run away from regulators because, again, organizations like the SEC, their mandate is to protect investors, right? So that's why they exist. So we don't need to run away, but we do need to be very clear about what we're saying, and we need to be mindful of that chilling effect.
Do you feel that it kind of seems to me that the majority of projects, that are considering launching should get a no action letter? Is that a general something to consider for the majority of projects, do you think, before they launch?
I probably run the risk of giving legal advice here, so I'm not going to say too much. I can talk about what we're doing, right? Like,
there you go.
We are fairly certain that the Coast stablecoin project is not a security. But despite that, we are going to the SEC with all of our written explanation to them of why it's not a security. And, I was talking earlier about how you build features that are regulator compliant, right? So that that when you write that letter, you're going to probably get a positive response. So we discussed different ways to build in mechanisms into the Coast stablecoin program where you could stake another asset in order to receive a share of the fee revenue that would be generated through the on-ramp and the off-ramp. And very quickly in discussions with our attorneys, we figured out this is probably going to be considered a security. What is the real benefit that we're providing here? Yeah, it's a good feature, but you need to drop that because you don't want to be in that discussion with regulators about it. And so instead we said, okay, well, what about if we do a discount instead? What about if people can stake an asset and it gives them a discount on all their on and off ramp fees? And I didn't realize this at the time, but my attorney turned around and said, actually, that's great. Discounts on features, discounts on ramps or products are not securities. So you can do that all you want, right? So this is what I was talking about earlier with, like, if you understand regs and if you take the time to interface with regulators and attorneys who do securities law, you can build features and feature sets that you know are very likely to be compliant.
Makes sense. Do you have a feeling on, I'm just curious, changing regulation? Do you have concerns about the way that they're looking at things differently than they have in the past?
Yeah, I mean, the best case of this is probably the one I referred to earlier when we're talking about HODL law against the SEC, this case that has been brought. I think the reason that it's been brought is because of the changes to the underlying consensus mechanism in Ethereum.
Yeah.
You know, under the previous administration, under Clayton, we had a pretty definitive statement or a press release from the SEC saying that Ethereum is not a security. It's sufficiently decentralized such that it isn't. I think the increased centralization and this potential censorship of transactions and a few other things that are involved in ETH 2.0 proof of stake probably mean that previous press release is invalidated. And I think that the efforts by HODL law in their recent filing are an attempt to get the SEC to clarify, again, that Ethereum is not a security.
Right.
So
this is another example of kind of what we were talking about earlier, where, you know, for the action letter, it has to do with how accurate your letter is versus your project. And so Ethereum has changed. And so then, you know, the old thoughts on the project only apply to the way the project used to be and not now. Correct. And Ethereum has changed. And so the question comes up again.
Exactly. It's a little bit different in the sense that the SEC in this particular case is being taken to court, right? They're having to, well, they're being asked to address this by a person who's bringing in a court action. This isn't a request privately being made by the developers of Ethereum, now under proof of stake, to release or provide a no action letter, right? This is a totally different process. And this is something that, you know, sort of concerned me a couple of days ago with the attempt to get this declaratory statement on behalf of HEX from the SEC. You know, knowing what I know about the SEC and how these things work, when I saw that was coming up, I immediately saw, hey, a declaratory statement by the SEC isn't a thing, unfortunately. But it was mentioned alongside a fundraising drive. And so my instinct when I saw that wasn't, hey, these guys who are doing it are trying to fleece hexagons and trying to raise money for their own legal cases or anything like that. My initial reaction was, oh, hang on. I know that this particular phrase that's being used, declaratory statement, isn't a thing. So who have they heard it from? Who's given them this advice? And how do we need to sort of, you know, not step in and stop this, but at least, you know, potentially provide some assistance because, you know, we have the capacity to do that. So, you know, we're in touch with RG3 and we're trying to get a meeting with him later this week to talk about legal strategy and about the way forward. Because like I said, you know, we're not trying to diminish what anyone has done here.
No.
You know, personally, I would not have gone out to the community and started asking for financial assistance on a legal strategy that was developed in the course of a single meeting, and where the goal of the action was not absolutely crystal clear. If you're going to say that you're seeking a declarative statement by the SEC, you probably should have clarity on what you're actually entering into and be able to tell the community that, right? If it's a massive legal battle against the SEC, and not a no action letter, I mean, those two things are so vastly different and involve such vastly different budgets and commitments. it's just worth noting, and you need to be able to answer that and describe how they're different. The
Yep.
instincts are great, right? And there could be an opportunity presented by these subpoenas. I'm going to try my best to speak with those guys later this week and give them any resources they need, or maybe there's a way for us to get a sort of second opinion on a legal strategy, and maybe that involves our guys putting something together and maybe, you know, backburnering the whole court case or something like that. But we'll see.
Yeah.
You know,
Yeah.
we're trying to start a dialogue. We're trying to be collaborative.
Yep.
We acknowledge here that the guys who went about that are trying to do the best thing by the community, and I think they always have. They certainly seem to have, in my experience, looking at what they're doing. But everyone needs someone who's looking over their shoulder and who's in their team or on their team, you know, looking out for them. And for the case of the Discourse Syndicate guys, that certainly goes for them, applied to the HEX community, and we're going to try and be that for them as well and give them that support in any way or shape that we can.
Great. I appreciate the way that you said that. Like, we are on the same team, and we can use our community and the experts in our community to help each other refine, you know, the best approaches for all our sake. And I think, like you said, I also feel the intentions are good. And I think that's great. Like, I don't have problems, like you said, with, I don't have ill intent. Like, are they actually intending to use funds for the betterment of the community? I think they are. I like what you highlighted with the specific verbiage that used may not actually be a thing. And I'm glad that you're using your experience to help refine this. I think I can't speak for them. I have a feeling that they're very open-minded and want to do what is best. So that's good.
Yeah, and look, to their everlasting credit, they've come out publicly. I wasn't able to be on the Twitter space the other night, unfortunately, but they came out and said, we are desiring of help. If you have contacts, we will talk to them. If you have a legal team that wants to collaborate with ours, we're open to it. This is not a group of people who are out there for themselves. It does not seem like to me.
I'm with you.
And so they need support the same way they're trying to support the community generally.
Yes. I do also appreciate, I'm curious your thoughts on this. Like, there's a healthy way to do it, but I do appreciate the proactivity that people in our community are actually trying to do something. And it doesn't always have to be reactive. Like the no action letters, it's a it's a proactive thing. I tend to think that's a good sign. But of course, the way you go about it needs to be wise, I guess, is how I would think of it.
I would love to see going and getting no action letters as the standard, but you have to be mindful of the fact that you know, this puts a 9 month, 9 month delay on your project or releasing a product. And you know, there are groups out there who are trying to build things and are trying to take the Facebook you know, move fast and break things approach. And you know, that's okay when you're releasing a social media tool. I don't think it's probably as wise when you're releasing something that's regulated by multiple federal agencies and has the potential to be described as defrauding investors. I think we need to be much more careful about this. And if any founders are out there, like I'm in the founders chat with KG, and I'm sharing some of the information from our attorneys with the group. And I hope to be a resource for other people in this space, because like I said, I'm talking to a securities attorney twice a week. I seriously doubt anybody else is. So we have expertise in this space if anyone wants to come to us and ask for it.
I've got a question here from 730 Bang. Would the fact that there's been multiple testnet versions launched so far negative no intention to ever release argument from the SEC?
Yeah, look, I might have phrased that poorly, and if I did, I apologize. There is almost no chance that the SEC could make that argument, and I seriously doubt they would refer it to DOJ to investigate something similar. I was really just trying to use an example. That is a circumstance under which that sort of thing would be referred out to see if there was collusion in the background to defraud investors. That's just an example.
Got it. Are there any other topics related to this that you would like to cover that you feel might be useful for our community to to understand?
Look, I think that's all I have that I was planning on speaking about. I think we've covered a lot of territory here. I do, if you don't mind, I just have one sort of thing to touch on about anonymity and about public-facing people, etc.
Yes.
Right? Because, like I said, I am in the founders chat, and we do get a lot of people sort of venting in there about other figures in the community demanding that we be public-facing people. And some of us just have no desire to be, right? Like there are some founders like Alex and Dipcatcher at KG that are public, and it's awesome that they are. They're putting significant resources into the ecosystem. But I've also seen like well-known figures in the community, people that you all know, just denigrating founders for not wanting to be public people. And then minutes later, screaming at the top of their lungs about the need for privacy and chastising FINRA and Uniswap for collecting user information. And I just find those people, and it's a very small number of them, to just be, disingenuous and narcissistic, frankly. Their conduct speaks of people who are, desiring some sort of fame or public adulation. It's obvious to me that they're not people with families who, for that reason, want to stay out of the public spotlight. So, look, Richard himself has said privacy is essential if you want to function in the world. And so, there are people who want to be public, and there are people who don't. And we're putting huge resources into building things for the community. And I don't think it benefits the community by us going dark and leaving altogether because we don't want to be public, right? Further to that, we've done KYC with Solid Proof, which is a similar standard to what RG3 and Kinetics did with the SEC, going to release KYC information. That information can be made publicly available via a court order in the event that anyone has a grievance against, me or Coast generally. And this is as much or more as any founder in the space has done. And we should be requesting this and demanding that this be the standard for US-based companies. It's very difficult to do it globally, but I think that should be where we're trying to draw the line.
What was that called again?
What was that, sorry?
That transparency, what was, could you say what that was exactly? You're just saying something should be done, that level of transparency is healthy. What was that exactly again?
Yeah, it's doing KYC and having a registered entity that if there is a grievance, a case can be brought against that entity or that individual. But it doesn't mean that you have to be completely public facing about what you do. It just means that there's legal recourse against you if anyone happens to have a grievance. And this is something you have to do when you're doing like money transmitter licenses, for example. If you want to go and get an MTL, you have to put up a bond. And those bonds are incredibly expensive. It's one of the reasons we've designed our business around not being an MSB or requiring MTLs, is to avoid those security bonds. But there are various different mechanisms to keep people safe in this sense. And KYC is one of them. And like I said, if there's a grievance against us for any reason, you can go and get all of our private information. It's just not something we want to broadcast.
Got it.
Yeah.
So we got another question here. How far is too far when talking about complying with regulation? Is there anything you would not comply with?
I would probably get legal advice on anything that I wouldn't want to comply with. It would very likely be, though, I'll speak in general terms again, not necessarily about us, but you can see a circumstance where a regulator would request something that they were not entitled to. Yeah. And in that situation, via your user agreement with your users, you would probably be compelled not to release that information unless that regulator went and got a court order and came back to you with it. So yeah, it's not unusual for a regulator to overstep their bounds in this way and ask for information similar to a police officer asking you to open your trunk without a warrant, right? Like this does happen. So we would protect our users, I believe, in any case that was an overreach of a regulator.
Another question here. I think this is another type of question I've had a lot. Richard Hart's not in the U.S. Daniel's not in the U.S. It sounds like. How does this affect? How does the U.S. governing agencies affect non-U.S. citizens? And I'm curious your thoughts on that.
It depends on the specific circumstances you're talking about, but this is why I was mentioning that chilling effect, because there is the real potential that you could be a founder getting legal advice not to release products or to return investor capital or not proceed with projects because of federal regulation in the United States. I think that there is a fine line that regulators are going to have to walk in this case to prevent that chilling effect, because you could certainly see founders picking up and moving and taking their operations to other countries that are going to be more cryptocurrency lenient or accepting of. You know, the UK is one of those. They're trying to be very forward facing in terms of regulation. So does it matter to you right now as a person overseas? Probably not, unless that chilling effect goes into effect, right? Like the take tornado.cash as an example, right? It used to be that you could interact with that contract easily via a front end, but then anyone who released a front end had, I'm trying to remember the term, sorry, a cease and desist sent to them, asking them to take them down. So does all of this matter if you're not in the US? Well, yeah, like if there's no front ends to interact with the contracts that you like, because all of the people who could provide them have been sent cease and desist letters by the DOJ or the SEC, yeah, it could, certainly.
Got it. This is another good question from Daniel. What is something you would conclude from all of this? How does this affect us?
I guess the question is what you mean by this in the last part of that sentence, right?
Is there
I'm not really clear.
I think we have kind of covered this a little bit, but from the user's standpoint, why does talking about the SEC and FinCEN and the governing agencies, the Department of Justice, why does this matter for, let's just say, Hexicans?
I think that chilling effect is a very real thing. I think that there is a serious impact on the people who have got us to this point as a community. You know, when you see people who say they're going to stream for 555 days, cutting it off at 100 because they've been subpoenaed. And I think that that's a real thing that affects all of us as a group. And, obviously we need to support everybody as best we can. But what do we conclude from this? Well, regulatory action, even if it's unwarranted, or even if it doesn't come to legal proceedings, can hold things in its tracks. Exactly.
And I've seen this not as much in the Richard Hart community. I've seen this in other communities, projects that I feel are very well intended and moral law, individual, like from a standpoint, seem very pure. Are actually not moving forward. It's the chilling effect that you're talking about, because they're afraid of going to jail sometimes, and they're afraid of the potential effects of things. And I see that happening, and I think that's a really good point.
Yeah, I mean, take LBRY as an example, right? I mean, their social media conduct aside, it seemed to me like they were trying as best they could to create a decentralized way to share video content. And not only that, but to provide SDKs that would allow you to skin it and put your own branding on it, right? So that it could operate as sort of a substrate and be white labeled. I mean, when it first started, I think that was a very well-intentioned thing for them to try and do or try and want. But, that chilling effect is real. And now we have the case that was brought against them and the summary judgment against them that probably is going to financially cripple them and cause them to have to stop doing what they're doing. Like, I don't necessarily think that's good. I don't know that it's good for LBRY investors. I wouldn't want to be a holder of LBRY when that judgment came down. So, again, fine line to walk, but there are real world consequences to this stuff. And if you were a person in a place that, for example, didn't provide YouTube for video uploading services, and you were a dissident in one of these places trying to get a message out, well, LBRY not being available to you might, be something that really matters to you and your organization.
Right. Well, Stoic, thank you for talking about this, answering our questions. I think we've covered some important topics that that matter to our community now. I think you've done it in a very respectable way, and I appreciate you coming on my channel to talk about this and the trust that you've placed in me to house you well. And I don't know if there's any other closing remark from you before we end this.
Yeah, the only thing I would say is, look, patience is really hard to have. It's hard to have it in a lot of circumstances with a lot of people. And it's especially difficult when there is financial stress placed upon you. And so before you respond to YouTube comments, before you subtweet people, before you really rip into other members who are probably trying to do the right thing, let's all assume good intentions on behalf of one another. And let's take the anxiety level down. I know that's difficult when you're in a 95% bear market, but we need to have a rational and a respectable level of discourse, because you never know who's watching, and that could be a regulator or it could be a potential user, and we don't want to drive people away because we're not welcoming and not accepting of our own.
I completely agree. Well, Stoic, thank you again for coming on, and I think this was a really good stream, and I think I'm going to wrap this up, and thanks again.
You bet. Appreciate it, Maxim.
Thank you all for being here and joining us for this. Talk to you later.